Thank you, Danielle. Thank you. Like Jeff, I used to work down the street at the Department of Justice. I was an assistant attorney general under President Reagan and Attorney General Meese. I'm pleased to say that I was present at the creation of the originalist movement when General Meese launched that effort with a remarkable address to the American Bar Association. Let me begin by echoing something. I'm delighted to share the platform today with Jeff Price because the work that he's been doing for the last year or so at what sounds terribly bureaucratic, OIRA, the Office of Information and Regulatory Affairs, seems gray. It's actually extremely important, and it has a pedigree that goes all the way back to President Nixon, who tried to get control of the administrative state by creating a point under the control of the president where when all of the agencies, including independent agencies, promulgated regulations, they had to pass through some kind of review controlled by the President of the United States. Now, the theory of that is not terribly complicated to those of us who merely read the Constitution of the United States. And all paths, by the way, in my remarks will come back to this. The Constitution of the United States, don't leave home without it. That applies to you too, Holger, and I'll get to that in a moment. Article 2 in Section 1 of Article 2 of the Constitution vests all executive power under the Constitution in a President of the United States, which means that any executive power that's exercised by anybody, whether it's a soldier, a lawyer, a regulator, derives from the president. They derive all of their authority from the president, and they are under the supervision of the president. And beginning with President Nixon, there was an effort to get control of this process. And strangely enough, it's contested. It's contested by the bureaucrats who don't like being supervised. It's contested by people on Capitol Hill who like having points of contact other than the president through whom they can get things done behind the president's back, so to speak. So presidents consistently, of both parties, but mostly Republican presidents, have tried to get control of the executive branch through various features. And finally, with the enactment of the Paperwork Reduction Act, President Reagan got authority to create an office inside the Office of Management Budget with somebody immediately below the director of that office, now to be the director of the Office of Information and Regulatory Affairs, to be that reviewing person. And that office has a tremendous pedigree from the time of President Reagan until the time of Jeff Price. I think the first director of that office was a guy you've all heard of, Jim Miller, who went on to be an economist, who went on to be the director of OMB. He was followed by Chris DeMuth, who ran the American Enterprise Institute for many years. He was followed by Douglas Ginsburg, who is now a judge of the U.S. Court of Appeals, one of the good guys on the U.S. Court of Appeals here in the District of Columbia. Wendy Lee Graham held that office. Naomi Rao, who's now a judge of the U.S. Court of Appeals, held that office. Some very super people have worked very hard to get control of the bureaucracy under presidents who were serious about it, such as President Reagan. But these guys in President Trump's administration and Jeffrey Price, who have perhaps done more to accomplish that in all these years. And that is because, and here's something that's very good news, and I think it's also something very dangerous. Donald J. Trump has given the world a master class in how to push the exercise of executive power to the extreme, to the maximum. He's pushed the envelope over and over again in direct control of the bureaucracy, in the use of executive orders, in the assertion of control over the independent agencies. We've got Supreme Court litigation underway right now over the president's control of things like the Federal Reserve Board and other putatively independent agencies and so forth. I remind you, there's no power in the Constitution to execute anything other than through Article 2, and that means the president, right? Now, that's all good news because we see very good things flowing from that, including the work of Jeff Price, right? The danger, of course, is that we're not the only ones who are paying attention to how to use these levers in such an aggressive and robust way as President Trump is doing. And there will be successor presidents who have very different political objectives than those of President Trump. There will be presidents who will want to reanimate the administrative state. There will be presidents who will want to use the powers of the presidency to exert ever more dirigist control over the economy. And as they do that, they will look back to the precedents set by President Trump in this amazing demonstration that we've seen for the last 14 months of the use of presidential power. We've been cheering it, and rightly so. But the question is, how do we keep those tools from getting those levers of power being controlled by people who have very different objectives and a less robust attention to the ultimate question of the freedom of the American people, including private property, free enterprise, and the like. Now, that's where the rest of the Constitution becomes extremely important, and that's why the role of the courts, a robust role of the courts in asserting the boundaries of constitutional authority, including forcing Congress to do what Congress often does not want to do, and that is to exercise its responsibility to make major decisions. Because if you think about it, Congress at any moment could roll back many of the excesses of the administrative state simply by legislating boundaries. Now, there are lots of political reasons why Congress doesn't like to do that. Part of that is the simple objective of most individual Congress members is simply to earn re-election. And how do you earn re-election? It is by avoiding making controversial decisions. And if the people get the sense that Congress is ultimately responsible for policy choices that are being made, well, then people get mad at Congress. So it's far easier for Congress as an institution to identify a problem, deplore the problem, create an agency to solve the problem, give the agency the name of the problem, like the Environmental Protection Agency or the National Highway Transportation Safety Administration or some such thing, and then delegate to it the responsibility for fixing the problem. Now, you know what happens, of course. It adopts regulations. People challenge the regulations. They go to court. It takes the court years to decide the challenges of the regulations. Then the regulations come back. They go in force. People don't like the outcomes when the regulations go in force. They challenge them in court again, right? And the litigation follows. And it's years, and therefore several election cycles, it's years that follow before the actual consequences of whatever it is that Congress did becomes apparent. And people can say, well, Congress was to blame, except that was Congress, 3, 5, 8 elections ago. In the meantime, members of Congress say, listen, I've done what I can do about the problem. I've said, executive branch, go fix the problem. If you don't like what's going on, blame the president, blame the agency, blame the courts, don't blame me. That is the heart of the problem, the evasion of the major questions responsibility of Congress. That is the heart of the delegation doctrine problem. Congress gets a benefit out of shirking responsibilities, doesn't it, in that electoral, in that political sense. And if there is something that the American people could do at the grassroots level on a daily basis to adjust that problem, it's simply to ask Congress to take responsibility for making major decisions. Now, the Supreme Court of the United States, in recent times, is doing its part by refocusing those questions, taking away the ability of executive agencies without the approval of Congress and the president to make major decisions by saying, we need to revisit these questions. The boundaries of power need to be redrawn. And that's why the overruling of the Chevron decision, which we just talked about this morning, and the reinvigoration of the major questions doctrine are so important. And what is at stake there is the vitality of the American experiment that we began 250 years ago with the Declaration of Independence, leading to the adoption of our Constitution some 13 years later. Now, that Constitution is rather different from Germany's Constitution in that it is even harder to amend than Germany's Constitution, and it has built into it not only some pretty strict separation of powers notions, which, if enforced, go a long way to protecting liberty, including liberty over private property and free markets, but also the First Amendment and the absolutely single most important legal question in front of all of us, including every one of you, which is your freedom of speech. Because freedom of speech is not only the heart and soul of citizenship in what ought to be a free country. Freedom of speech is also the heart and soul of the scientific method, isn't it? That is the essence of the scientific method. It is the freedom to pursue the truth and speak your results. Tell the world what you know. Tell the world what you question. Tell the world what you doubt. And tell the world what must be doubted and what must be tested in order to pursue those doubts. There is no scientific method. There is no scientific process without freedom of speech. And that's why the core responsibility of people who work and try to defend and vindicate the Constitution of the United States has to be the protection of the freedom of speech. Now let me speak to one last matter in litigation that I think this audience, our friends, the friends of all the sponsoring organizations, including the Heartland Institute, will appreciate, because we have often ourselves, whether individually or institutionally, been defendants or near defendants in lawsuits of the kind I'm about to address. On February 23rd of this year, just a few weeks ago, the Supreme Court of the United States agreed to decide a case coming up from the Supreme Court of Colorado. That case was brought by the commissioners of the County of Boulder and the city government of Boulder, Colorado. And they sued the Suncor Energy Corporation, a couple of its entities, and the ExxonMobil Corporation. This is a lawsuit that they started in state court. And what they sued for was state torts by the energy companies for doing what? For selling fossil fuels to create the climate crisis. I'm not making that up. These are selling fossil fuels and thereby creating the climate crisis with impacts in Colorado, they claim violated common law rights against public nuisance, private nuisance, unjust enrichment. Also violated the rights of Coloradans under the Colorado Consumer Protection Act. And then also they charged conspiracy. Now, what's the wrongdoing that they claimed that the energy companies had done? First, selling fossil fuels, and thereby causing the climate crisis to the injury of the people of Colorado. And second, defrauding the people of Colorado by knowing the truth about the climate crisis and hiding it. Now, on that last theme, of course, we want to chuckle. Hiding the truth about the climate crisis? You claim that the energy companies had secret knowledge about what use of fossil fuels do. The energy companies had secret knowledge about what goes into the atmosphere. Al Gore has been telling the world, the United Nations has been telling the world about the truth of climate science, right? About the dangers of emissions. By the way, Holger, you showed us a very interesting muddy picture of a source of carbon dioxide emissions. Behold, I am a source of carbon dioxide emissions. Right?
Yeah, this is what I mean.
Yes. The lawsuits contend that the energy companies knew the truth and hid the truth. Now, that's a pretty far-fetched notion given the immense public debate over the climate issues. But think about it for a moment. They also charged conspiracy. And who were the other participants in the conspiracy if you wanted to broaden the conspiracy beyond the energy industry? Well, wouldn't you know it, everybody in this room is a member of that conspiracy, aren't we? We all speak up in opposition to the consensus. And thereby, by the lights of these litigants, we are parts of a conspiracy and should be not only silenced, but made to pay the county and city of Boulder, Colorado, for whatever the climate crisis has cost them. The energy companies responded to this first by removing the case from state court, from the Colorado State Court, which I think makes sense because the local plaintiffs are bringing the case in the local court and they're suing people from outside the state on a theory of local law, Colorado state law, governing the issues, the controversies in the case. And the first thing that happened when they got to the federal district court in Colorado was that the plaintiffs moved for remand back to state court on the theory that it fell under an exception to the federal jurisdictional rules. And the state court agreed. Rather, the federal court agreed and remanded the case to the state court, the state trial level court. The energy companies appealed to the Court of Appeals for the 10th Circuit. The Court of Appeals for the 10th Circuit affirmed the lower court, and so the energy companies then took the case to the Supreme Court of the United States. This is a while back. And the Supreme Court of the United States thought about the matter, and over a dissent by Justice Kavanaugh, denied certiorari, denied review. So the case went back to the state courts in Colorado, and the first thing that happened in the trial level court in the state court in Colorado is the energy companies moved to dismiss for failure to state a claim. To put a little flesh on those bones, they argued that they did nothing that violated the common law rules of torts, but more important, there is no state law of torts that governs this. It's been preempted by federal law, beginning with the Federal Environmental Acts, the Clean Air Act, which completely, the argument is, vacates state regulation of the field, and the trial court denied that, saying it's true that the Congress, in enacting the Clean Air Act, vacated the federal common law of such torts crossing state lines, but that leaves in place the state common law, the law of Colorado. Thank you very much. We'll proceed with this case. That decision was appealed to the Supreme Court of Colorado. The Supreme Court of Colorado, with 2 dissents by justices of that court, affirmed the trial court. And then the energy companies came back to the Supreme Court of the United States on the question of whether or not this case can go forward to trial in Colorado, or if it is in fact preempted by federal law, if this is a case, because it implicates interstate commerce, international commerce, and the powers of the federal government that have been asserted by Congress in that field, the case does not belong in state court at all. And that is the case that the Supreme Court of the United States has agreed to take up. Now, that case is being briefed now, and it will be decided, it will be argued, I'm sure, in the fall. I don't think we have enough time between April and June to get the case fully briefed and argued now. So it'll be heard next fall, and it'll be decided sometime within the next year by the Supreme Court of the United States. Now, in order to decide that case, the court, because it's faithful to the Constitution of the United States, is going to have to address the questions of whether or not it has jurisdiction to decide that case. There will be an interesting fight that probably is more interesting for lawyers than it is for citizens and scientists about whether or not the Supreme Court has jurisdiction to decide that case. But I think there's a pretty good indication. It takes a minimum of 4 justices to agree to decide a case, and they took that case knowing that they have to decide the jurisdictional issues. So I think there's an appetite for the Supreme Court of the United States to decide this case. And I think they understand both the implications of this case for the question of federal preemption of state attempts to regulate this field on a piece-by-piece, on a case-by-case, state-by-state basis in a way that, of course, would create a patchwork quilt of regulations, 50 different state rules regarding cars and gasoline formulae and who has to pay what penance for being a quote-unquote climate denier. Now, the significance of this case, it goes, I think, beyond the mere dealing with an annoying bit of litigation in Colorado, because many of us in the room know that this isn't the only case of that kind that's been brought around the country. They've been brought in New York, they've been brought in Illinois, they've been brought in Hawaii and several other places, often by the same law firm that goes around to local governments, city governments and county governments, and saying, listen, this is going to cost you nothing. We're going to sue the energy companies, and by the way, anybody else who might be part of their conspiracy. So there's somebody, some organization, local organization that's constantly yipping that there is no climate crisis, we'll sue them too, and allege that they're part of the conspiracy that's defrauding your people and preventing the truth from being spoken. You don't have to pay us anything. We'll sue them for damages, and when we collect the damages, we'll take a third or whatever the proportion is that we agree on. So this kind of litigation is not unique. What is unique and important about it is this is the first time that this litigation and the qualitative aspects of it that merit judicial scrutiny have finally gotten to the Supreme Court of the United States. So watch this space. In that case are bound up questions of the power of the judiciary to shape jurisdictional questions, the power of the federal government to assert supremacy in the field of interstate and international commerce, and the duty of the judiciary to protect against improvident uses of state law to shut down speech by alleging that part of the tort, part of the wrong, is suppressing truth in a conspiratorial way. All of that is on the table. And I am optimistic that we have an opportunity here to strike a serious blow for freedom through the judicial system. Now, when I look at you, ladies and gentlemen, I think of Danielle's opening remarks about the importance of evidence, the importance of factual evidence. Is Steve Malloy in the room? Steve Malloy is my colleague on the board of the Heartland Institute. I don't see Steve here. Steve, as you know, has been a champion.
He's speaking on the other panel right now.
Well, the nerve of that guy. Steve has been a champion opponent of junk science. And what has evolved under Rule 702 of the Federal Rules of Evidence that Danielle described is a fairly increasingly rigorous process of weeding out junk science from federal litigation. And I look at this room full of people who are genuine experts. I think any number of you I could put on a stand and qualify you by virtue of your experience and your methodology as legitimate experts to be able to present evidence to a court. Several times during the day, I've heard other speakers refer to you as an incredible group of people. I want to apologize for that insult. There's nothing incredible about you at all. What I have found in this room, in 16 iterations of the Heartland Institute's International Conference on Climate Change, is nothing but credible people. And I thank you for your faith in the Constitution of the United States, and I thank you for your courage to speak the truth to power. God bless you all.